Topic of this video is to discuss the recent changes announced by the USCIS about scheduling asylum interviews. So on January 29th, the USCIS Asylum Division announced that they will prioritize the interviews for the applicants that filed asylum applications on January 8th or later, so within 21 days prior to the announcement. We had a meeting with the USCIS Asylum Division Director yesterday, which was very productive, where he provided lots of valuable information and answered many questions that are related, and I'm here to share those answers and the information that I obtained from that meeting with you. So the change that the USCIS announced is that within any applications that have been filed, any asylum applications that have been filed beginning from January 8th and going forward, up to date and in future, the USCIS will consider those applications as the first priority. The first priority will be the applications, the interviews that have been rescheduled, but that has always been. So this priority is now that the USCIS will consider these applications that have been filed between January 8th until now, and will schedule those interviews as soon as possible. Now, what does as soon as possible mean? As the division director yesterday emphasized, there is no certain timeline they have at this moment. It all depends on how many applications they receive between now and then. And they do receive a lot more applications, and the number of asylum applicants gradually grows. So if you ask me, I will say that if you filed your asylum application between January 8th and now, you should expect somewhere between 1 month from now or 6 months from now to be scheduled for the asylum interview. What the USCIS Asylum Division Director also emphasized yesterday is that those applications that have been filed, those applicants that filed asylum before January 8th will not be forgotten about. Those applications are not frozen. They will be also scheduled in due course for their interviews. And the USCIS Asylum Division will dedicate or had already dedicated officers to review those cases and to schedule those interviews. A couple of the important points that were made yesterday during the call was that there are currently over 300,000 cases in the backlog. The division director stated that the main cause the backlog started was sudden growth of the applicants, but mainly limited budget that is assigned to the asylum office. Just in case if anybody is curious why these backlogs occurred. They had only 250 officers, around 250 officers about 4 years ago. Now they have hired twice more, so approximately another 250. So currently they have about 500 asylum officers. Then they're planning to add another 100. They've been authorized. The Asylum Division has been authorized to hire additional 100 officers. So the plan is to have about 600 officers. Some of those officers are being diverted from affirmative asylum cases, which is the asylum interview scheduled for, to border credible fear interviews. And the division director confirmed that the border applications are growing, and there are much more credible fear interviews now than it used to be before. So this also causes some of the backlog to grow. The division director said that there are about 50,000 or more of the applications filed by individuals who have been who entered the United States more than 10 years ago. As we all know, the asylum applications must be filed within 1 year of the entry of the applicant into the U.S. There are certain exceptions, such as extraordinary circumstances or changes in circumstances, such as the basis for asylum had just arose because of the changes in the government of the applicant's country. but those usually extraordinary, exceptional circumstances, it could be also maintaining your status, usually occur or add another year or half, or if the asylum application is slightly delayed. And usually it's expected might be a year or two later. But if an applicant has filed an asylum application more than 10 years ago after living in the United States, it's highly unlikely that they have real basis for asylum. I'm not saying it's impossible, but it's unlikely. So therefore, the asylum office now decided to, and they did, beginning from last week, began sending letters to those applicants, offering them to accept the decision on their asylum case based on the documents they filed. So if a document facially shows that they are past the 1-year deadline and there is no real basis provided, then the asylum application will be forwarded to the immigration court. So they sent these letters, as the division director confirmed. Hopefully that will reduce the backlog by about 25% or so because of the number of those applicants. Then, in terms of the applications that have been filed before January 8th, the Asylum Division Director also stated that those applicants can file for expedite request, and those expedite requests will be reviewed on case-by-case basis. Specifically, there was a question asked, what is the criteria? And the response was that the officer reviewing the expedite request or the officer assigned to the case will be the one to make the decision, and the division director did not provide any specific criteria or explanation on how to request those how to request expediting the asylum interviews. So what to take out of all these changes? My take out of it is that the asylum office is trying to obviously reduce the backlog. The idea is positive. The goal is positive. How it will be implemented left to be seen. And a lot will depend on how they implement this. So the idea is that asylum backlog had substantially grown over the years, not only because of the limited budget, but also because of the backlog itself. And what I mean by this is that there are many applicants that filed as for asylum because it was easy, because they knew that the case would be pending for many years, and because they would be eligible for work authorization. So it was perceived, unfortunately, by some as a means of legalizing their stay in the United States, be it temporarily, but for several years, and legalizing their employment in the United States, even if they didn't have the real and actual basis. And so to prevent that from happening, now they promulgated this change so that the applicants don't count on being able to remain here or get a work permit for many years until their asylum case is denied and until they're placed in removal proceedings. About removal proceedings, one other thing that the division director confirmed is that there has been a directive issued to the immigration court and immigration judges to try to expedite those cases that will be referred to the immigration courts in case of the negative asylum office affirmative decision, so that even in immigration courts, those applicants shouldn't expect to remain for many years until they've been ordered removed, or they can apply for voluntary departure and depart the United States within 120 days if the voluntary departure is granted. So that's the change, and that's a positive change. Obviously, we want to filter the frivolous applications. We want those who have real basis for asylum to be interviewed timely, not to remain in the limbo for many years. So the announcement is positive. But the limitations in the number of officers, my opinion is that they have to also increase the resources. Yes, they will hire 100 more officers, but will that help? It remains to be seen, because as the division director also stated, that the number of applicants grow gradually, the number of cases asylum officers dedicated to the border credible fear interviews grows gradually and continues to grow. So the result remains to be seen. But there is also a lot of panic I see on the social media and on the internet that they will be more strict about, or that they will be tough about granting asylum. There is no directive, there is no announcement, there is no instruction to the officers about being tougher or being more skeptical of asylum applications, as it was announced by the director of the division yesterday. So there is nothing, there is nothing other than this announcement of prioritizing the 21-day applicants and about so far sending these letters to the applicants who filed more than 10 years after their presence in the U.S. The other announcements from yesterday were that the USCIS plans to establish a central vetting and intake location, service centers, somewhere in Atlanta, and they're working on it. They're planning to do it in 2019. What it means is that all the asylum applications would be filed there initially, and the USCIS that division will take care of the initial filtering for fraud, for security, national security issues, and they would assign it then to local asylum offices for the interviews. Again, that's also a positive change if the government does dedicate sufficient resources for that to be done diligently and timely. But it would not be a positive change if it just creates another bureaucracy, another hurdle for the asylum applications to get to the point of the real officer reviewing the case and scheduling the interviews. So the risk is that anything new they create can cause uncertainties and difficulties. Again, the applicants that had filed before January 8, nothing is certain. Your cases may be even further delayed because now the asylum officers resources are dedicated to interviewing the new applicants. But at the same time, your interview date may be accelerated if the whole plan, the goal, the idea behind it does work and it's properly implemented. There were several other questions unrelated to this recent change that are helpful to address. Is one of the things that was important that was asked. A lot of asylum applicants, because of the backlog, they've been waiting for their interviews for many years. And the question was, what happens if that individual has another basis to adjust status or gets married in the U.S.? Can they put their asylum case on hold while their case is, the adjustment of status, their marriage is being processed? The answer was that there is no procedure for holding asylum process. There is nothing that you can do to freeze your asylum case. You can either withdraw it, or you can continue your asylum case even though you're obtaining your permanent residency through marriage. And as I explained in other blogs, in my own other blog, was that you don't necessarily have to withdraw your asylum claim while you're going through the permanent residency through marriage, because they're too independent. They're independent from each other. You get the protections through asylum that you wouldn't get protections through marriage-based green cards, such as, the exception from public charge bar, then exception from eligibility for federal benefits and social benefits, travel document, which you cannot obtain. If you get married to a U.S. citizen and get your green card through marriage, you're still citizen of your country of origin, and you still have to use that passport to travel overseas. You're not eligible for a refugee travel document, which would substitute your passport. And the risk there is that if you have fear of returning to your home country, or if the government of your home country is after you, then when you travel to a third country, even though you're a U.S. permanent resident, that third country will perceive you as a citizen of your home country. And if something happens, or if there is an issue, or if your government of your home country's government has extradition treaty with that third country, they can extradite you to your home country. And the United States is not going to do anything about it because you're not a U.S. citizen or refugee who's afforded protection by the United States. So with that, you don't necessarily have to abandon it. It's not a good idea to abandon your asylum process just because you're getting your permanent residency through another means. So this is this much so far, and the next blog I'm hoping to discuss how to prepare for asylum interview and what to expect at asylum interviews. So stay with us.